What's up, everybody? It's bright and early here, but so many of you tagged me in this yesterday, and I saw some stuff come out about it, and it's just mind boggling to think that this is still happening in 2024 with all eyes on a case like this, cameras in the courtroom, people reporting every motion that's filed, every order that's handed down, that the system can still look this bad. I don't know what else to say, but this is not a good look for the system. It's not a good look for justice. It's not a good look for fairness. It's not a good look for due process. And we're going to discuss an order today handed out by Judge Gohl on the Delphi case for Richard Allen. We broke down last week or the week before and the weeks prior all of the issues between the judge and the defense lawyers, kicking them off the case inappropriately, the Indiana Supreme Court doing something that's pretty unusual, putting them back on the case, allowing Richard Allen to have his counsel of choice, and overruling in the middle of the pretrial phase the trial court's order removing these lawyers for being incompetent and grossly negligent. So how does Judge Gohl feel about that? We talked about Raspbaum yesterday in the Adelson case and how he's handling the big loss with respect and working with the other side and doing his job and representing the next client. And we've had examples of people reacting and responding appropriately and properly to motions and trials and hearings that they lose, and then people acting inappropriately. And I think this one is starting to feel like the latter. So Judge Gohl was overruled. The lawyers are put back on the case. Obviously, some hostility between the defense lawyers and her, but the Supreme Court did not remove her from the case, even though there might be a pending motion for her removal by the defense lawyers. But were they actually the lawyers on the case because she had removed them and accepted their oral withdrawal as their withdrawal? So are they even allowed to file that motion for recusal? All that stuff's kind of up in the air, which just adds to the mess and cloudiness of what's going on right here and probably adds to the reason that this stuff is happening so fast. So hit that like button if you guys haven't already. We're going to dive into this order. We're going to talk about all the issues with it, where we think the case is going, and why we take issue with things like this. We're going to discuss all that and more in today's video. Also, make sure you subscribe to our channel. So I'm going to bring up the order here to read through it. And I know it's going to be impossible for you to read. I'm going to read it. It's short, but I wanted to give a shout out to Defense Diaries. It's a Twitter page and I think a YouTube page as well. I've been on with him on I don't know, Law and Crime or Court TV or something like that. But he has been following this case and posting everything about this case, going to the hearings. And a lot of people tagged me in his post of this order. And I mean, it's just wild. He's a defense attorney. And so, we look at this stuff a certain way when we're on this side. I don't know if he's prosecuted cases, but I've prosecuted cases too. So we see it from both sides. And he clearly from his tweet is not happy about how this is going down either. So let me read this order here, then we'll discuss it. Order issued on 1/22/24, which was yesterday. The court, having had defendant's motion for Frank's hearing, filed September 18th, 2023. This is the huge Odin. Other people did this. It wasn't Richard Allen. He's actually innocent. All of the issues in the warrant, they left certain things out. They misstated certain facts. They left out descriptions that would not have fit Richard Allen. They basically worked around the rules to get this search warrant, and everything found in that search warrant should be suppressed. That was that huge couple of motions and memorandums of law attached and exhibits attached that we read and broke down together. That was absolutely wild. If you want to check out the deep dive of that, it's in our Richard Allen Delphi playlist on our YouTube page. She's had that motion. She's had the memorandum in support of the accused motion for Frank's hearing, the defendant's supplemental motion for Frank's hearing, the defendant's additional Frank's notice, the state's objection to the defendant's motion to suppress, and the state's second objection to the defendant's motion to suppress under advisement. So she's had them all. She didn't have hearing on them like we've seen in so many other cases. I had the motion, I heard the case, and here's my ruling. No. She just had these motions, and now she's issuing her order. What is she doing? Well, she now denies the defendant's motion for Frank's hearing without hearing, just straight up denied. The court finds the affidavit submitted in support of the issuance of the search warrant contained information that a reasonable belief existed that evidence of the murders would be found in the defendant's home and vehicles. The court does not find that the affidavit submitted false statements or that the affidavit omitted statements with reckless disregard, nor does the court find that the affiant intended to mislead the judge by failing to present information. Now, here's what's really interesting about this and wherein lies the problem. I don't have a problem with her ruling. I may disagree with it, but this is a totally appropriate ruling. If she reviewed the facts and the evidence and the testimony, and she came down that, you know what, I don't find false statements, I don't find it misleading, I don't find that the affiant was trying to mislead me, but do it with due process. Let them have the hearing, let them present the evidence on the record, let them question witnesses, let them present witnesses, cross-examine the affiant maybe. Let them do it the right way. And then if you come down and you deny it, that's fine. That's your job as a judge. But when you do something like this, right after you take a big L, I don't know how that felt. She knows how it feels now. So she takes a big L and almost immediately comes down with this order on a bunch of huge, obviously important, it goes without stating how important these are, motions. Now, why did she do it that way? There's a couple reasons to look at this, a couple ways to look at this. Number one, I would assume they're filing another motion to recuse her or renewing that motion now that they are, in fact, back on the case, according to the Supreme Court of Indiana. Number two, maybe she wants to assert her authority and say, you might have won that, but guess what? You ain't winning anything else. That's what it feels like, right? And if you don't want that appearance of impropriety, if you don't want that appearance of impartiality, like we talk about all the time for judges, how important it is. A lot of people had problems with Judge Newman in the Murdoch case. I disagreed with some of his rulings throughout trial. Did he let a little too much in? Yes, maybe no. Did he give them a million chances? Did he wait till certain questions were asked? Did he warn them? Absolutely. He let due process happen. He made a call as a judge. That's his job. But to do this repeatedly without due process, to remove these lawyers outside the rules, as I understand it in Indiana and most jurisdictions, in chambers behind closed doors, not with the defendant there, taking an oral motion, overruling the defendant, wanting these lawyers to be his lawyers. Obviously, that was wrong since the Indiana Supreme Court already did it in the middle. We don't even know what that opinion is, by the way. Their opinion could also block Judge Gohl, or at least delay certain things, or say we've got to wait till this motion for recusal is heard. There are some issues that opinion could bring up. Maybe that's why Judge Gohl is slamming the hammer right away. But this is what railroading looks like. No due process. We don't even care what it looks like. We don't even care what it sounds like. And I'm not even saying it's involving the prosecutors. Maybe the prosecutors are sitting back like, ooh, they're just doing their job, right? Filing objections, arguing against it, obviously, preserving that evidence. But this is not a good look from the bench. And it's even more mind-blowing to me that she is well within her rights to have this hearing, grant this hearing, which, by the way, with the new defense lawyers, now old defense lawyers, the defense lawyers that replaced Rosie and Baldwin, when the new guys came on, she seemed to infer that she was going to allow an evidentiary hearing. And then, boom, you want these lawyers down? Fine, you got them. Careful what you wish for. That's what it seems like to me, to an outsider, okay? I don't know this judge personally, never practiced in front of her. But from the outside looking in, from a lawyer's perspective, I would not be happy with this. I would not think this was fair. I would not think this was due process. I would absolutely try to get her recused. And this would be something I would put in as an exhibit. How she was going to let other lawyers handle it, but not us. And again, what's mind-blowing is all she had to do was have this hearing and then come down with this written order and make specific findings. And then let's keep it rolling. Let's keep it moving. But she chose to do it this way. Okay. I don't remember where I was. The court finds the affiant submitted in support of the issuance of the search warrant contained information that a reasonable belief existed that evidence of the murders, okay, I read that, that they did not mislead the judge or present false information. Okay. As the court has found the affidavit for issuance of the search warrant was valid, the search itself was reasonable and legal under Indiana law and the Fourth Amendment case law. Defendant's motion to suppress fruits of the search of 1967 North Whiteman Drive, Delphi, Indiana, is also denied based upon all the pleadings, memorandums, and exhibits previously submitted in support of the request for a Franks hearing. Now, what's annoying about that is when judges usually make specific findings, it makes it easier to find problems or appellate issues. When they just say, looking at all the pleadings, denied, it's much more difficult to find appellate issues. Defendant's motion in limine regarding ballistics is reviewed and denied without hearing. I mean, give me a break. This is crazy. Like, denied, 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 denied. I'm going to kick you off. Oh, you're back? Well, guess what? Deny everything you did. Thanks, but no thanks. You wasted your time. The court finds the evidence contained in the defendant's exhibits A and B attached to the motion is relevant and admissible. The court further finds the probative value of such evidence is not substantially outweighed by its prejudicial impact, and that the evidence will not confuse or mislead the jury. Defendant's motion to transfer is taken under advisement pending the state's response, if any, and a hearing to be set. State's motion to amend information will be set for a remote hearing. I believe this most recent motion for transfer was filed by the new lawyers that she likes. And we'll see if that ends up happening. And we'll see if he ends up getting transferred. But basically everything denied without hearing. You lose, you don't pass go, you don't collect $200. And I'm fine if I disagree with judges. I tell you every time there's a lawyer that disagrees with the judge's ruling. Two lawyers fighting about something, that's why a judge has to make a call. One of the lawyers are going to think the judge got it wrong. But we have watched and experienced way too many cases together for you all to be fooled out there in the chat, in the YouTube sphere, in the public true crime world. This looks and smells different. We've seen people lose hearings. We've disagreed with it. We've agreed with it. We've seen guilty verdicts. We've seen not guilty verdicts. We've seen multi-million-dollar civil verdicts. We've seen $0 civil verdicts. This is not how it's done. This is not what the justice system is supposed to look like. It does show you, and it's a learning experience on the power a trial court has, the discretion they have, how it's hard to fight against this stuff, how the judge, frankly, and a lot of people are going to be like, oh, here's an appellate issue. It's like, she probably doesn't care. Because, yeah, it's an appellate issue, but it's like, after he gets convicted, good luck. Years down the road when this appeal is getting heard, what's Richard Allen's physical and mental state going to look like? This is majorly problematic and not how it should look. And it's not so much her ruling or even her reasoning for the ruling. That's appropriate. That's how she views it. That's within her discretion. But to dismiss them without further argument when she seemed to be open to having the evidentiary hearing and argument with other lawyers seems to be punishing a defendant for the lawyers that he chose, which is absolutely inappropriate for a judge, for a jury. You hear lawyers say, hey, I might sound like a jerk. Don't hold it against my defendant or my client. I'm just doing my job. Let me know what you guys think. Do you think I'm being overly sensitive about this? What do you think the tone of this order is? The timing of it, the context of it? Do you think it's just another day and she's just picking up her docket? These happen to be there and she's issuing her rulings. What do you think? I want to hear it. And again, this has nothing to do with Richard Allen's guilt or innocence. It has to do with his rights as a criminal defendant, his presumption of innocence, his right to a fair trial, his right to due process, his right to a competent counsel of his choice. That's what this is really about. All of ours in America, everybody's rights. We don't want law enforcement trampling on them. We don't want prosecutors trampling on them. We don't want private lawyers trampling on them. And we definitely don't want judges trampling on them. So we're going to see how this plays out. I can't wait to read your comments and questions. But that's all I got. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.